our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I'm blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is FinCEN's Transparency in Residential Real Estate Transfers Rule. That's a mouthful, but we're going to be talking about it. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, YouTube, and X. On each of those platforms, you can find us at the handle @InRem Podcast. Go to YouTube, like and subscribe. Helps us out a ton. Also, you can download an audio version of the podcast on Apple, Spotify, or any other major podcast platform. Go there, like and subscribe as well. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So our legal update today is what is a tenants in common agreement and when should it be used? So a tenants in common agreement refers to joint owners of real estate who enter into an agreement whereby they're going to own that real estate as tenants in common, not as partners, not as joint venturers, but as tenants in common. So when would you want to use that? You're going to want to use a tenants in common agreement when one of the partners, or I shouldn't say partners because they're not partners, but one of the co-owners, when they intend to sell their interest in the property and effectuate a 1031 exchange. So they want to basically be able to sell, use those funds to buy another investment property, what they call a like-kind exchange, buy another similar or like property, and not have to pay capital gains on those funds from the sale of the original asset. So let me just give you a hypothetical. Two investors decide that they want to go in together, start investing together, or maybe just buy one property together. And there's multiple ways to do that. But one way, and one common way, is for them to form an LLC, with each of them being 50-50 members of the LLC. And then the LLC that they form actually takes title to the property. Well, in that scenario, neither owner can effectuate a 1031 exchange because the LLC is the one that actually owns the property. So in order to do the 1031 exchange, both members would have to agree, and then the LLC would actually have to sell the property and buy another property. And once again, that same LLC would have to then acquire that property, the new property. And so basically these two partners are bound together always and can't go their separate ways and do a 1031 exchange on their own. So in order to avoid that, the partners may end up deciding, well, we don't want to be partners per se. We don't want to be joint owners of an LLC. We want to have the flexibility, each of us, to sell our respective share of the property and do a 1031 exchange and deploy our capital somewhere else. So in that case, you would purchase the property, presumably in two different LLCs, one for one owner and one for the other owner. And those LLCs would then enter into what's called a tenants in common agreement, which basically discusses their responsibilities as owners of the property. And common agreement and say a joint venture agreement or a partnership agreement is that a joint venture agreement or partnership agreement provides for the allocation and distribution of net profit. And so basically you look at all the expenses related to the property, any type of repairs, vendor expenses, commissions, etc. All of that goes into, the hopper, and then you take the gross receipts from the property, you apply the gross receipts to the expenses, and from that profit number, which is then distributed in terms of the partnership agreement or joint venture agreement. In a tenants in common agreement, that's not what happens. In a tenants in common agreement, each tenant in common is responsible for their proportionate share of the expenses of the property and to pay those expenses directly. And then they also are to receive not the net profit, but the gross receipts of the property according to their proportionate share. So if they own it 50-50, they get 50% of the gross receipts. If it's 40-60, then one partner would receive 40% of the gross receipts and the other would be 60. But there's no determining what the net profit is. There's no application of the gross receipts to the expenses first. Those gross receipts go straight to the tenants in common. And that's necessary for the tenants in common agreement to be proper and meet the IRS regulations so that you can effectuate the 1031 exchange. So a tenants in common agreement is one that's entered into when multiple parties intend to own real estate, and one or more of those parties want to reserve for themselves the ability to sell their interests in the property and deploy their capital somewhere else using a 1031 exchange.
All right. Thank you, Sean, for the legal update. With that, a couple of announcements. Every day, or every Tuesday, I should say, at 3 o'clock p.m. Arizona time, that's 3 p.m. Arizona time, we have the Creative Finance Collective. That is an opportunity, a live video feed of professionals in the space of creative finance and real estate, where we get together and talk about what we're seeing in the creative finance market, problems, successes, legal issues, legal changes in the law in regard to different states, as the case may be. And we talk about it. But what we're really there to do is to answer questions from you, the listener. So we're on for as long as an hour, but really until we stop getting questions. So if you've ever wondered the mechanics of a creative finance transaction, maybe you've seen YouTube videos of investors talking about this as a strategy, and you want to hear what that looks like from a lawyer's perspective, the risks, the rewards, the benefits, the disadvantages, so on and so forth. We talk about those and work through them. So we're there to answer your questions. Make sure to be there with us, 3 p.m. Arizona time. And you can find that on YouTube, Facebook, and X. It's a live feed just like that. Join us, post your questions in the chat, and we will get to them. Look forward to seeing you guys later today. Also, in today's discussion, we're going to take any questions that we get. We'll answer those in the final 15 minutes of the broadcast, but don't wait until then to post your questions. We're monitoring the chat. You go on as you're thinking of your question or something comes up. Don't wait to post it. You'll forget anyway. Post it now in the chat, and we're monitoring those, and we'll get to them. All right, so let's get into our topic today. We're talking about FINCEN. That's an agency, an administrative agency, and we're talking about what's known as the Transparency in Residential Real Estate Transfers Rule. And with us to discuss that topic is attorney out of Georgia and Alabama, Drew Jenkins. Drew, how you doing? Good to see you.
Hey, good seeing you guys as well. I think last time we were talking about the CTA, the Corporate Transparency Act, and FinCEN's just not leaving us alone, are they?
No, they're not leaving us alone. And every time we feel bothered, we bring you back on to explain for us what is going on and what we can do about it. So for those that might not be familiar with you, Drew, why don't you give us a little bit of your background, how you got into doing what you're doing?
Got it. So I used to do a lot more of creative financing in the residential space. I got started with the We Buy Ugly Houses franchisees back in Alabama. And we used to joke it's not just ugly houses, it's also ugly titles. And then from there, I worked with a commercial real estate firm for a while, and I handled SBA closings, right? SBA 7A. And it was a lot of fun. Did a lot more on the residential with the wholesalers and the assignors, but again, as the rules keep changing and the underwriting gets tougher, and I also have an ability to handle commercial, my practice has actually moved more towards the commercial side. I know last week we were discussing about the about the land wholesalers, and I have a few of those clients as well. It's not as simple as the TikTokers or whatever may make it sound like. But I enjoy working in more of the commercial space these days than necessarily residential, although I still have a fair amount of that. So we have a title company, we have a law firm. Our offices speak Korean, we speak Spanish, we speak Mandarin, and we have clients basically from all over the world because of the background we have. A lot of our folks are not only out of state, but even out of country. So that's kind of really what our specialty is and what we do.
Drew, so what is the name should our listeners want to reach out to you, the name of your law firm and title company?
You can reach out to Jenkins Title. On the legal side, we call ourselves Maplebridge Law. So they can go to maplebridgelaw.com or jenkinstitle.com, which will redirect to Maplebridge Law.
All right. So why don't we break down for the listener who's maybe an experienced real estate investor, but they hear terms like FINCEN, they hear these exotic, transfer rule terms, and they're like, well, this sounds way over my head. Sounds pretty serious. What is this? So let's just kind of on the front end break this down for them and start with a simple question. What is the transparency in residential real estate transfers rule?
The breaking it down simple is they're turning us into banks, right? So when you go to open a bank account, you have to provide, your beneficial ownership information to the bank, not only for the entity, but also who manages the entity and also who owns the entity. This is going to sound very, very similar to the Corporate Transparency Act we spoke about in the spring, and that's because the rules have an awful lot of overlap. And the reason that they can do this is because under the original regulations for the Bank Secrecy Act, financial institutions actually include settlement agents. So even though we were granted an exemption from the large scale banking anti-money laundering rules, they always had the ability to drag us in. And that's exactly what this does. So now when you go to a closing, you're going to be handing the settlement agent or title agent or preparer of the deeds. They have a cascading responsibility list about who's in charge, but reality, it's going to be your settlement agent or it's going to be your closing attorney. It's going to be like opening a bank account. We are going to be mandated under the Bank Secrecy Act's rules and FinCEN's new transfers rule to acquire information about your entity, to acquire information about who makes decisions on behalf of your entity, and to acquire information on who owns your entity. And we are going to hand it all over to the financial criminal enforcement network, FINCEN. And they're going to add it to their database to figure out whether or not you are trying to clean dirty money. So we're becoming a bank.
So yeah, it sounds like a lot of work, and we'll get to that in a minute. But previously, we've talked about the Corporate Transparency Act. And so, it uses the word act, which I think has some significance legally. But this is actually a rule. So what would be the difference between, say, an administrative agency rule or a rule that's passed and an act like we talked about with the Corporate Transparency Act?
No, that's perfect. I mean, even lawyers get these distinctions wrong, right? All laws are laws, they're just not created equally. An administrative rulemaking has the force of law, but itself is not a law, right? Because the law is the systems of requirements and obligations. An act is a specific legislative event that creates, new laws. And our particular Congress, they're not specialists really in anything. So rather than pass very specific laws, they pass these very broad and bare bones acts. And then they rely on the agencies that they empower to actually, fill in the details. And so that's what rulemaking is, and a lot of these regulatory rulemaking is these are the details underneath these very broad empowerments to prevent fraud or, to increase transparency or whatever it is. So it is not a law in the sense that any legislative body said, yes, this is what we require you to do. It's more of an advocation of creating laws, right? Saying, we don't know enough about this, so we're going to give these other people over here the ability to have the force of law, and we're calling those rules. So that's the difference between rule in this case and the act and the Corporate Transparency Act.
Now, these administrative agencies, they actually fall under the executive branch. So obviously our executive branch is changing come January. And if the new administration doesn't like this rule, is it a simple stroke of the pen to say, we don't like this rule, it's out? Or would there be more of a process involved to actually get rid of this rule that we're going to talk about today?
I mean, it's funny you mentioned that because even the agencies themselves, it's not really the stroke of a pen, but because they're creating their own rules with force of law, they always have the ability to reinterpret or to revise their rules. And so it would go through a similar process, right? As they would say, hey, either we're thinking about removing this entirely, or we're going to reclassify it. Or as you said, the president could, with the stroke of a pen, very simply say, we're not enforcing this rule, right? Because there's too many rules to actually, and they don't. Congress does not allocate enough funds to hire enough federal employees to actually enforce all of the rules. So the executive has the ability, and you see this, you're exactly right. With every changing administration, they will prioritize the enforcement of certain rules, and they will deprioritize the enforcement of others. So with the stroke of a pen, a new incoming administration could very easily allocate no employees to this, particular endeavor, and it would effectively not be enforced while they go through the process of revising or repealing, which would also be a rulemaking process subject to comments as well. So yes, with the stroke of a pen, we might wake up, January 21st, and lo and behold, it's not going to be implemented, even though it will stay on the books.
Mm.
Now-
So if it's not implemented, would you as a title officer or a closing attorney, would you then feel still obligated, like it's on the books, I better report this information? Or would you be like, well, they're not going to enforce it, so it's no harm, no foul?
Well, we would have no way to report it. They haven't actually given us the real estate report yet. So for
Hmm.
those who are not familiar with the Bank Secrecy Act, and it's called the Bank Secrecy Act because banks have to be very secret. But every time you engage in certain types of transactions, they tattle on you to the government, and they're obligated to do so within a certain number of days. It's generally what's known as a suspicious activity report, or a SAR. And the real estate report is basically a streamlined suspicious activity report. So if you fall into a certain category of transactions, we have to tell FINCEN what has occurred within 30 days, right, of the transaction occurring, into the month or 30 days, right, whichever is longer. So yeah, I mean, we can't report until they give us the report in the system to do so. So even if it's on the books, if they don't bother creating the portal for submissions or giving us, the format in which to submit it, we're not able to comply. And I am certain that there are rules on the books that are, people are unable to comply because the government never set up the mechanism for compliance.
Now, Drew, I was told, I guess going back into law school, that the idea behind administrative agencies was to delegate, to have Congress delegate to the experts to figure out some of these issues that were maybe too burdensome or too voluminous for Congress in and of itself to deal with. So they've created the experts in FINCEN, and FINCEN and all of its expertise has decided to impose this rule. Now, having said all that, I was told, and I understood that real estate was one of those things that kind of mattered at the local level. We cared about ordinances that were passed and state laws that were passed, state property tax laws that were placed or imposed on property, and that's why we cared about it at the local level. We're not talking about the local level anymore. So what is the purpose behind, the experts here's decision to impose such a rule on something that's really kind of a local issue?
It comes out of what we spoke about earlier, the geographic targeting orders. So even though I only practice in 2 jurisdictions, I am an approved attorney for most of the underwriters, just by a function of how Alabama's title underwriting works. So I get everyone's underwriting memos from all over the US. And there have been for years this concept known as geographic targeting orders. So the federal government has been very concerned about cash transactions in certain locations, right? DC, Baltimore, parts of Florida, having illicit sources of funds, right? Money laundering. So for years, they have been requiring that title companies and closing attorneys in those jurisdictions report, very similar to what is now going nationwide. And they found through that process that apparently 40 something percent of all transactions indeed had typologies, which is a term that you see referenced again and again in the commentary to the new rules that are hitting, that matched money laundering typologies. And because 40 something percent of all of those transactions that were reported matched, they think that they're missing out on the bulk of these potentially illicit transfers. And so now they're just going to roll it out nationwide. So that's what's happening is they did geographic targeting. They found that less than half of all transactions had indicia of illicit activity. And they decided, you know what? This is a great thing. We're going to roll it out nationwide at an estimated cost of $630 million per year. Yeah, the comments are really interesting if you read them. They're estimating the annual burden of this program to be somewhere between $430 to $670 million per year, at an estimated cost of an additional 4.2 million labor hours to file these reports. But the intangibles they think are going to exceed $500 million per year. So it's totally worth it to incur an additional cost of 600 and something million to get an intangible value of greater than $500 million and 4.2 million labor hours. Yeah.
Wow. So one wonders, we're entering a phase, and this is just me watching the news, but a huge talking point in the coming administration is all about government efficiency, right? One of the things that they announced is the DOGE, the Department of Government Efficiency, where they're looking for ways to scale down the government where it's not efficient. And I remembered my macro or maybe microeconomics class in college. There was almost no case where the government was more efficient at things. They almost never are. But so they're not going to have a hard time finding cases where the government's inefficient. But boy, this sounds like one of those things that might likely be on their radar in terms of an inefficient use of government resources.
I think it would be, because we also have to remember that even if you look at FinCEN's website, right, they talk about illicit funds, money laundering. That conjures up an image in their head, drugs, terrorism, things of that nature. But if you actually pull the reports from FinCEN about, the cases they're finding, obviously, you do have drugs, you do have terrorism related items, but you also have things like so-and-so ran an unlicensed money services business, an unlicensed transmitter, basically an unlicensed Western Union or MoneyGram. So-and-so ran an unlicensed lender, because you have to realize from FinCEN's perspective, dirty money doesn't necessarily mean you were involved in an illegal, enterprise involving, guns, drugs, or things like that. They simply mean you didn't pay tax, because if you don't pay taxes, then it's not legalized yet. And so a lot of laundering is actually, cash businesses who fail to report, and, they're trying to legitimize their money in a way. And so that's really quite a large portion of it. One case I saw that they felt like publicizing was somebody sold cigarettes. They caught an enterprise that was smuggling unregistered cigarettes in the city of New York. This is money laundering to them. I mean, they're right. It is money laundering. But again, the image that they conjure doesn't necessarily reflect what they're actually going to be attacking, which is, people that are not declaring their taxes, and thus the income is, from their perspective, illicit and illegitimate.
So before we go into the inner workings of the rule, let's talk about the effective date. When do closing attorneys, our law firm would have to take some steps for compliance, for deed work and stuff like that we do. But when is the date for compliance currently set?
December 1st, 2025. They're giving us plenty of runway to get ready.
So So we've got a year to get ready. Well, when was the rule announced? It was announced relatively recently, was it not?
It was. I don't know the exact date it was not. I remember we had our discussion of the CTA this spring, I think, May. And I
Yeah.
told y'all I felt something was coming. And then I think
Mhm.
it came in like July or August, I think is when they
No.
announced it. They went through their 90-day rulemaking period.
Mhm.
It has since expired, and now we have the final rule is taking effect December of next year.
Okay, so they announced August 2024. We've got to the end of, well, December 1st, 2025 to prepare for compliance, um, assuming that the rule is in effect at that time. Uh, just one other question's kind of just more of a broad question. Have you seen any rumblings or suggestions? I mean, everything is these days challenged in some way in court. But any discussions have you seen as to the constitutionality of the rule? Because, we're talking about, you know, just like the Corporate Transparency Act, a reach from the federal government into something that is kind of inherently local, right? And something that usually would be left to the states.
Yes. So the good news about any federal rulemaking is it is all available at the Federal Register, including all comments. And I mean, the government does a very good job of walking through each of the comments and explaining why they have either adopted the suggestions, they clarified several bits and pieces, or why they declined. And so obviously people wrote that it was an unconstitutional overreach. And the problem is, and I didn't know this, is when the Bank Secrecy Act was first passed, however many decades ago, it actually includes settlement agents and title underwriters. So
Mm.
we are, in fact, financial institutions defined in the Congressional Act way back when. It's
Mm.
just, FinCEN had determined that we were such a low risk that they had, through their rulemaking, exempted us from the banking's AML requirements. And we still are exempt from their AML requirements. They've just created a new streamlined one, especially for us. So their response, I thought, was very straightforward: is it's in the act, right? Congress defined you guys as being under our jurisdiction, therefore you're under our jurisdiction.
Mm. All right. Well, there it is. And until I guess that law's challenge, I guess you would have to then challenge that congressional act as to whether that is constitutional in and of itself. But if, like you said, if it's already defined in congressional law, they would appear to have the rulemaking authority at a minimum to deal with those.
To regulate us to some extent. Now whether this extent, obviously Chevron deference got overturned recently, and so I'm sure
Mhm.
there could potentially be a tax that, yes, you have the right to regulate us, however you do not have the right to regulate us to this particular extent. I don't do litigation, so I don't know, but I could see somebody probably crafting an argument, using those lines, because again, saying that they can't regulate us, that ship sailed a long time ago. Question is how much.
Well, and as we'll talk about, this FinCEN rule actually goes further than settlement agents.
Yes.
And I could be wrong. I'm not as up on the banking regulations as you are, but I doubt that they put or encompass private attorneys within that banking regulation. Maybe they brought in settlement agents or title companies, but I would be surprised that they would have some, link or bring in attorneys who frankly have a duty of confidentiality for the most part with respect to their clients. But maybe we're in
So
there.
that was raised. That was also raised in the commentary. There were a couple of bar associations that said, this is going to be a violation of, client confidentiality.
Mm.
And several other bar associations said this is wonderful, we love it. And the position of the government is, if you read the ABA model rules, which have been adopted, most recently revised, you have, attorneys do violate confidentiality to comply with, criminal enforcement, with laws, right? So if the government reaches out to you and says, I need you to turn over certain documentation, you, under the ethical rules, are obligated to do so. They've been adopted by the states. We obviously are, a criminal enforcement network, and we are telling you, as part of your responsibilities, that you need to turn over this information. So they just kind of hand wave that one away, saying you're obligated to do what we say as attorneys to begin with under your ethical guidelines. And again, apparently there were several bar associations that think this is a really great idea.
Shocker.
But there were some that apparently they were the ones that said, we think this is an invasion of client confidentiality, which again, they pointed out, well, no, it's not, because you're already obligated to listen to us anyway. And you're not turning over anything that they don't already know or that they should not already know. That was the other thing, is people brought up under the beneficial ownership index, right? Well, why can't we just rely on this? And the point is, that's at a point in time, this is at the time of transaction. So if somebody has altered ownership structures, right, we won't catch it just by referencing the BOI. That's why we need it here. And we're not asking you to turn over any information that you or them are not already obligated under different sets of law, be it under, the CTA or under, IRS tax filings, to be disclosed anyway. We're not asking you for anything we don't already have. We're just telling you that we need it in a new format so we can more properly link them to figure out, again, who is engaging in types of transactions that indicate illicit activity.
So let's get into what transactions are subject to the FinCEN reporting requirement with the new rule. What does that look like?
So it is the CTA on steroids. Any and we have to be very careful with this, because it's not just cash transactions. It is any transaction that basically does not involve an AML financial institution, right? So if you have your friend Bob as a private lender, we're still subject to this, right? If you have a small private lender, a hard money lender who is not abiding by the CDD and the AML requirements under the Bank Secrecy Act because of how they're structured, we're still under this filing. So it is all transactions not involving we'll call them what's the right? I mean, I don't want to call them traditional lenders, but it's just lenders who are not obligated to follow the Bank Secrecy Act. And the transferee is itself an entity or a trust, so it's broader than the CTA, then we have to file. It's very simple. There were lots of people that wanted thresholds, and the government said, no, that's just giving them a way to weasel around this. It doesn't matter. This is a great point someone pointed out. Do we have to disclose minors? Like, what if a child is the sole beneficiary under a trust? And the answer is, oh yeah, we need their social. We need them disclosed. Right. It is very broad, but it's only for residential real estate, and they defined residential real estate very interestingly. I know, right? I see you shaking your head, John. It's like, yeah, they only care about residential real estate that does not involve a BSA compliant lender into an entity, which includes trusts. And residential real estate is vacant land upon which there is an intention to build a residential structure, or land upon which the principal purpose of the improvement is as a dwelling, which also includes like cooperatives and like, those weird northern, co-op type structures. So it includes not only deeds, but it also includes like transfers of share certificates for the co-ops up north. Very, very broad about what's going to get filed.
So the vacant land with the intent to build on, just in addition to just sticking solely to residential, but vacant land with the intent to build, I could be wrong, but how many like money launderers buy land with the purpose to build? Like, is that really a strategy to hide money? Like, what, and then second, how do you as the closing agent determine whether they intend to build or not?
So again, people filed, comments, and they spoke about this. They relaxed our rules. So unlike banks, we are entitled to rely on affidavits, basically. So just like we already have, you're probably not familiar, but if you have a foreign seller of U.S. property, the tax withholding is determined by A, the purchase price, and B, the buyer's purpose for the property. I don't know why the seller's tax withholding is premised on the buyer's intended use, but here we are. I mean, I kind of do know why, but it's interesting. It's to incentivize people to sell to occupants, buyer occupants. But it's the same kind of concept here. Is we just have to ask, hey, this is vacant land. What do you plan to do with it? Are you going to build a strip mall? No reporting requirement. Are you going to build some houses? Reporting requirements, right? I mean, and unless we have reason to believe otherwise, we are entitled to rely upon the representation of the transferee and the transferor.
And my understanding is that the settlement agent is the one with the duty to report. The parties to the transaction don't have a duty to report. Is that correct?
Unless one of the parties to the transaction is acting in the capacity on the cascading list and they are the highest one. So unlike our IRS rules or whatever, this one does not impose the burden on a single person in the transaction. It actually imposes, because again, not every transaction is going to have a settlement agent. Not every transaction is going to necessarily have a title underwriter, right? But every transaction will have someone who is preparing, the conveying documents. And so they have created a tiered structure based on someone's control of the transaction, including, this is a very funny one, whoever disperses the most money. So let's say that we're not exactly sure who's going to fill these roles. So, one of our levels is whoever disperses the most funds in as part of this transaction, they are going to be our reporting person, unless you all agree in writing to designate someone lower in the hierarchy as the reporting person. So yeah, what you guys said, when you go to prepare a deed for a client into his LLC, doesn't matter there, and it's a house, doesn't matter, there's no consideration, you're going to file the report. Very simple.
So there's no such thing as, well, I just won't get a closing agent, therefore I don't have to comply.
That is correct, because ultimately whoever is filing the document, and so the funny thing is some of the local recording offices apparently made comments, and they're like, well, does that include the clerk filing the deed? And they're like, no, it's whoever gave the document to the clerk. That's our reporting person. So if two parties get together themselves and they decide they don't need lawyer, like think about all the time, especially in wholesale, you get people that do quit claim deeds. Well, I hate to break it to them, one of them is a reporting person. And I hope you don't screw this up, because the penalties are pretty vast.
Interesting. What about the definition that the rule uses? You talked a little bit about this with trust and entities, but it talks about, does it include partnerships in terms of entities?
Well, we have to be careful with this. So if they are a partnership, then yes. If they are simply, a husband and a wife acquiring a house, which, theoretically would be some kind of partnership together, the answer is no. So entities can include partnerships if it is in fact intended to be treated as an entity. But if it's just a couple of folks as individuals, then the answer is no. So if you deed it to your family members and y'all weren't like actually a partnership, then no. But if the purpose were to conduct business together, I guess, or as a partnership, then the answer would be yes.
Well, that's the point of, I guess, where I was going with the question, in that the law generally, state law typically defines a partnership very broadly. It's not like it's something that's filed with the Secretary of State or the Corporation Commission. It is usually just defined as a endeavor with somebody else with the idea that you're going to bring in some sort of profit. You know what I mean? So it's very, and that really, other than an exception where your spouse and you is exempted out, that's literally any time that you own real estate with somebody else, right? If somebody else is on the deed, that's probably a partnership.
Yes, and transferee entities do specifically include 31 CFR 1031.320 J10. Examples include corporation, partnership, estate, associations, think your HOAs, or limited liability company. Among the exceptions, FINCEN proposed, whose ownership or controlled or wholly owned by an exempt entity, final rule, transferee with technical edits to add to 2 specific exceptions. They removed SEC because it's only used once. And they removed the item ownership interest of the regulation now excludes any legal entity controlled or wholly owned or directly in controlled by an accepted legal entity to avoid potential confusion. So obviously banks are accepted, right? So if a bank forecloses on you and they take possession as a financial institution, they're exempt from these, so they don't have to file a report on themselves. But if you're not an exempted entity, then you're getting filed on. So yes, partnerships are reportable.
Yeah. So if two, if myself and my brother end up going on title to property and we have an arrangement amongst ourselves how we're going to split everything up and we're on title, that's a partnership and we probably have to do the reporting.
Yes. If it's residential property. I mean, if you do the same thing with the strip mall, no.
Right. So let's talk about what this is going to do as far as costs. So the transactions that are going to require this reporting, and you'll probably identify them early on, I'm guessing you're going to have an increased fee or an escrow fee or reporting fee or some amount that you're going to pass on in that particular transaction.
Right. So another good thing about the federal rules are, as part of this, they have to also do an economic benefit test or economic analysis. And they have estimated that the filing of these reports should amount to about 2.75 hours. The truth is, I think that's a very an extremely mine went blank on the right word, but I don't think it's going to take 2.75 hours per file, right? For the typical file. I think it might add streamlined maybe an hour. I mean, if you did it all at one time, you're probably at 30 minutes, right? But the problem is you're going to have to ask for documentation from all these different parties, and you're going to have to remember them and compile them. So, I mean, you're probably close to an hour per file. Not only that, but it's not only the amount of time, but it's also the amount of risk. So final rule of not more than $1,394 for each violation, an additional civil penalty of up to $108,000 for a pattern of negligence, in addition, a term of imprisonment and a criminal fine of not more than $250,000 or both. In addition to that, there is another civil penalty, and the greater amount involved in the transaction not to exceed $300,000 or basically $70,000. And that includes any violation of the BSA, which would even be an unlawful disclosure of information. So not only is it going to take more time, but we're going to have to be compensated for the additional risk. If we screw up, we're staring at those kind of penalties. So yeah, price is definitely going up for residential real estate.
So then let's talk about some of these exemptions. And the one that bothers me the most is, and I know why they did it, but it seems unfair, is they exempted out publicly traded entities. So your Wall Street firms who are buying residential real estate in cash are excluded from this, correct?
Yes.
And they don't have to pay the extra fees to close these transactions.
Yes.
So basically, FinCEN, call it what it is, they've given Wall Street a competitive edge in the residential real estate game.
Always. I mean, what else is new? Always, right?
Oh boy. Amazing. Yeah. So they don't have to comply. They don't have to pay the fees. And now your middle class, your mom and pop, business owner is now having to pay extra fees in order to compete with Wall Street investors.
Right. Now, not only that, there is another interesting thing here, and I am very curious about what it's going to do to foreclosures. Because several commenters pointed out, well, what if we don't have the information? What if we're dealing with an overseas, party, and we're not able to get the information? Can we file a partially filled form? And the answer is very clear, no. And of course, the penalties apply for not acquiring the information. So the way this is going to work is deals are not going to close until we get the information we need to file basically the residential real estate suspicious activity report. So what happens in foreclosures where, an entity rolls up to the courthouse steps, they purchase at a private foreclosure, and they're not disclosing to the closing attorney, the answer is those deals are going to fail because you can't, I mean, I'm not going to close that transaction until I have what I need from the buyer. So I foresee issues. I foresee very serious issues with the implementation on the courthouse steps for those kind of transactions that occur very quickly and with literally no due diligence, because that's how auctions work, right? Whoever has the most money wins.
So yeah, I don't see an exemption for a conveyance by say a sheriff's deed or a trustee's deed.
So there is an exemption for transactions that are supervised by a court. So if
Okay.
somebody's in probate, that is going to be exempt. If somebody is conveying a deed pursuant to a bankruptcy trustee authorizing, that's going to be exempt. What is not exempt is the typical private sale foreclosure. But if
Right.
a court is not just involved, but if a court is actually like directing the deed, those transactions are exempt. But if there's simply a court involved, off to the side, those transactions are not exempt. There were a whole lot of people that wanted answers on that point, and that's obviously when they were like, "Look, we agree with you. If this whole thing is being supervised by the court, you're not going to have to file it because we have the government involved directly in the transaction. But if it's merely occurring, and a court is somehow involved, but they're not directly running the transaction, then you are still going to have to file."
So basically, trustees on non-judicial foreclosures are going to
Yes.
have to file this report.
Yes.
Yes, I'm getting out of the game.
And one of the things that you have to file is the transfer or information, right? Like the seller information.
That is correct. Yes. Yeah.
So what if the
they're
trustee
hitting
does,
everyone in the transaction?
yeah, what if
You have to get it.
the trustee doesn't have that? You're foreclosing. You don't have a cooperative.
So according to
Seller.
FinCEN, according to the rulemaking, you have plenty of time to get them to cooperate, right? And you have mechanisms to get people to cooperate. That's just yeah. They
My
very
house has
much
been foreclosed
hand
upon
waved
me. Yeah, you
away.
want information from me? Like,
Yeah, good
no.
luck.
Yeah.
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 Pound sand.
Now, according to them, I can see their logic though, right? You could not have borrowed money unless you gave the lender in the original. Because think about it, we have those forms at closing that contain their tens. So you can always just go back to the lender and say, "Hey, you're obligated to have this information. I need it to give the government again." So I can see where they're going on that. Let's see. Yeah. The other thing was they wanted an exception for the tens because they didn't feel comfortable, collecting literally everyone's socials and then, having to store those for 5 years. And the government basically hand waved it away and said, "You're already collecting this stuff anyway, right? Or at least you're collecting some of it. So you already have, storage, storage ability to begin with because you're already reporting 1099-S. Maybe you're reporting Form 8300s. So you're already, you already should have, the compliance standards in place for this." There's quite a bit of hand waving.
So I thought another interesting exemption that applied, which sounded good until I thought about it, would be a transfer made for no consideration by an individual or with their spouse to a trust of which that individual, their spouse, or both of them are the settlor or grantor. Like, okay, that makes sense. Like when I do estate plans for my clients and I move their home into the trust, like, oh, okay, we don't have to comply. That sounds great, right?
Until you had kids.
But yeah, till you potentially add kids into the mix. But what I realized was it uses the term no consideration. So if I have cash in the bank, right, and I want to go buy a new house for my family in my revocable family trust, and I show up and I make a cash offer, and I'm going to then buy that property in the name of my family trust, fully revocable trust. It uses my social security number. and I acquire that in the name of the trust through a cash transaction for which I pay consideration, all of a sudden I now have to report that as an individual, basically buying in my family trust.
Yes. That would be true. The comments and the discussion regarding trusts was one that I see very commonly, right? Wealthy people, they have their lake house in the name of a trust, but they borrow money individually. So rather than do an accommodation mortgage, you deed the property out of the trust to the individual borrows, and then they shove it back into the trust. That's the situation that they are exempting, which again is an extremely common occurrence. But that's what they're accepting, is that exact situation, not what you're discussing.
Yeah. So if I go buy it into my fully revocable trust, that basically me and the trust are the same until I die, I have to report. That seems just, I mean, it just seems like an intrusion, like beyond.
So what you do is you buy it in your name first, and then you just transfer it into your trust, and then boom, you got it.
Right. And then you don't have to do it. The next day you transfer it into your trust.
So what about, I know that more things than just the sheer conveyance of all fee title to real estate happens by deed, such as like the creation of easements. Are easements and the creation of easements by deed on residential property exempt?
They are exempt. That is correct. It is the conveyance of the ownership interest that they care about, not necessarily the other ancillary rights of way or uses of the property, right? And again, it's not just deeds, because apparently up north with the co-ops and stuff, it even includes stock certificates if it is, used in lieu of a deed in that jurisdiction.
So break down for us when we talk about, okay, we've talked about the exemptions of who is to report, what needs, and what's exempt to be reported. But when we're reporting, how extensive is the report? Are we just naming the persons of the transaction? Is there additional detail required about those individuals? How exhaustive is that?
It's not as exhaustive as a suspicious activity report, if you've ever had to file one of those before. They do not require an analysis as to why you're filing, which is part of the SAR. But what they do want is, again, like opening a bank account, right? I need to know this person's name. I need to know their current I need to know the entity, right? Who are they? Where are they? Now, the good news is when it comes to trusts, they originally wanted everything about the trust, but they eventually did relent and say, most states have adopted, uniform trust certificates or something very similar. So we're going to negate that down. We want to know who formed it, who are they, what's their TIN, what's their address, who's the trustee, what's their TIN, what's their address. If the beneficiary has a right to demand, principal from the trust, what's their TIN, what's their name, what's their, mailing address. So it's just like opening a bank account is functionally what they're requesting.
Well, and going back to the example of where, like in a non-judicial foreclosure, the trustee sale would have to report information from the individuals they're foreclosing on. I mean, does that include like, identifying information like social security numbers?
Yes, it's the TIN. You have to provide the TIN, and every U.S. person has a TIN, and there is no exception for that. There is an exception for where one of your parties is a non-U.S. person and you don't have a TIN, then you can't leave it blank, because remember, you cannot file a not fully filled out form. But what you can use is you can use their passport number, or you can use their, whatever their identifying document is.
Yeah, see, where I could see you really having a problem, especially in the trustee sale context, is, yes, of course, if it's conventional loans and there's servicers in place and all that stuff, there's ways to get that information. But every now and again, you get the folks that just did their own, or they had somebody drop contracts. They did a seller carry. They kept a note. They didn't use a servicer. They were just monitoring it on their own. But it's been some time, or somebody died, or whatever else. They don't have social security information, right? They've got the names on the loan, and that's it.
Yeah, I don't know how you're going to close those without running afoul of this rule.
You're forced to doing a judicial foreclosure at that point, it sounds like. I mean, so that you get the court to approve the transfer.
Or the buyer has to be an individual.
Oh, yeah, that would be, yeah, right.
And then they just put it into the LLC after they buy it in their individual name.
And then they would
So-
do the transfer on their own reporting.
Yeah, I guess they would be. Yeah, and then but
Yeah.
then you wouldn't need the seller's name because they're already listed. So if you're a seller, you know, as you can tell, I'm annoyed that a bunch of this information has to be given to the feds on just a basic real estate transaction. And if I'm a seller and I'm selling, I mean, I'm not sure I would, even if an LLC showed up, I'm not sure I would, because I don't want my information reported to the Fed. But if I'm hearing you correctly, if I sell to an LLC who's buying my property in cash or using hard money or something, I have to likewise give all my information over to you, and then you give that to the Feds, right?
Well, the truth is, you're giving it to me anyway, because I have to file a 1099-S, and I have to maintain a tax certification, the 1445, FIRPTA exemption, and I have to maintain a state level version of the FIRPTA as well. So the truth is, as a seller, I'm already collecting and storing that information just for different purposes. It's for tax purposes.
I don't
It's the
remember
buyer, though.
having.
It's the buyer that I don't have to collect it. I mean, I've asked my underwriters, well, what if the
Okay.
buyer doesn't want to give me anything? And they're like, is it cash? What do you care? Right? If somebody wants to put it in the name of an entity and they're a cash buyer, what do I care who runs the company? You don't. So what's kind of got us
Right.
is, again, we already collect all the seller's information to comply with IRS and state level tax authorities.
Hmm.
We are not currently required to collect anything on our borrower or on buyers, cash buyers. We still have to collect for borrowers because we have to determine authority, right, for signing, because you can't just have, I can't sign on behalf of Microsoft, right? So thing is on cash, we now have to collect the same kind of information that we have to collect on our sellers, and we have to report that not just to the IRS in the form of a 1099-S or an 8288, but we now also have to report this new real estate reporting.
So if you were a betting man, we'll get your opinion on this. Based upon the outcome of the election and the change in administration, what do you think the chances are that this rule actually makes it to December 1 of 2025 and is rolled out?
Well, I think if the Doge is successful, I think it will not be rolled out.
Okay.
If they are
there's a chance
not
it doesn't.
successful, then
Right.
I think it's going to get rolled out. And I think in the context of foreclosures and things like that, it's going to get real messy real fast. And there's going to be some sort of an emergency rulemaking to adjust to realities on the ground.
Hmm.
Let me bring up one more scenario. I'm looking for an exemption that I think must apply, and I'm not seeing it. So I want to make sure I'm not missing it. But one common thing I know lawyers see, estate planning lawyers, real estate lawyers, is the asset protection attorneys that are moving rental properties into LLCs to break up their assets, right? So family puts it into family-owned LLC. It looks to me like there's an exemption for if you, of course, want to do that as into a trust that your trust. But it looks like it's going to be covered if you want to move like a rental property into just a garden variety LLC, right?
It is correct. There is no
Oh.
exemption for that. It
Yeah.
is an extremely broad.
Well, all right. If violating the due on sale clause wasn't enough, now they throw this at us. You just can't do anything anymore. All right. Well,
yeah, you're right. If you were doing it for a trust, you're A-okay. So long, again, it is a transferee trust. You are, synonymous. You or your spouse, but not your children. You or your spouse are synonymous with, all of that. Then that's exempt. But anything else, anything more creative, we have to go tattle on you.
well, the scary thing is for a lot of like just mom and pop lawyers out there that aren't paying attention. They just work at the local level. They're not paying attention to FinCEN. And, I can create an LLC for you and do this and just transfer it. I could see a lot of attorneys just unsuspectingly just running afoul of this, overnight.
Yes, no, I am certain that a lot of folks are going to run afoul of this, just given its broad-based nature and the fact you don't even have to have a closing. Again, the cascading thing will put, whoever dispersed the most funds or whoever delivered the deed to the recording office, they're the reporting person. I mean,
Yeah.
I think about all the QCDs I see these people, shuffling properties, internally between themselves. I mean, yeah, there's going to be a lot of violations.
Yeah.
And in Arizona, we have a whole segment of the legal community that are certified legal document preparers. So they're not even attorneys. And their whole thing is to prepare legal documents, which a lot of that work is deed work, where they're transferring properties to LLCs, like Andy said, for asset protection. I don't know. They don't use the word certified legal document preparer or legal document preparer, but I'm guessing they are going to fall under this act and be a reporting person.
It could be depending because remember it's a cascading scale of responsibilities. So if they are the highest level in that transaction, they could potentially be, but not necessarily.
Yeah. Oh, it looks like we lost you, Drew. Oh, we lost Drew. Well, you know what? That was the end of the episode. So we appreciate Drew being with us and going through this. Really technical stuff. We'll be watching it. We're going to see what happens. We'll keep you and all of the listeners up to date as to what happens with the FinCEN reporting transfer rule. And we'll see how that goes. With that, everybody make sure to join us today at 3 p.m. for the collective, and look forward to seeing you next week for our next show. With that, we'll see you next week.
Have a good day, everyone.